think the overwhelmingly most important issue is the concept of flexibility. And what I mean by that, in South Africa, as is the case with almost every other country, you have a Single Companies Act regulating every company in the land, from the biggest to the smallest. And that's a big challenge, because not everything that's appropriate to a big company is necessarily appropriate for a smaller company. What's happened in South Africa is, to a fairly large extent, companies are allowed to regulate themselves in their own constitutions, taking cognizance of their own requirements. So there's a new definition in the Act called alterable provisions and unalterable provisions. And an alterable provision is one where, notwithstanding what the Act says, the company in its own constitution can regulate itself. There's some provisions which are unalterable. Then, despite anything that's said in the constitution of the company, the Act would prevail. So that concept of flexibility, in my opinion, is the most important feature of the new Act. Another very important issue is the business rescue. In South African company law at the moment, a company is either alive or dead. And if it dies, it has very serious implications for three groups of stakeholders. 1, shareholders; 2, creditors; 3, employees. And in a country that is really intent on creating and preserving jobs, we need a mechanism for taking sick companies into intensive care, nursing them back to health, and getting them back into the economy. Preserves jobs, and it can be very beneficial for the other 2 groups of stakeholders as well. For the first time in South African company law, the duties and responsibilities of directors have been codified, have been described in the Act. This is part of a worldwide trend. It's happened in England, it's happened in Australia, and that is, it's designed to make a knowledge of directors' duties and responsibilities more accessible. You're asking people to become directors, they want to know in 1 or 2 pages what are their duties and responsibilities. And that's been the reason for codifying directors' duties. In my view, the new Act doesn't change at all the duties and responsibilities of directors. It preserves the current position, almost in their entirety. What benefits I see flowing from the new Act? I think that it's more cost effective. I think it's easier for smaller companies to comply. I think it's got that flexibility feature that, to a large extent, companies can regulate their own affairs in accordance with their own circumstances. It accords with international best practice, so it's investor friendly to foreign investors. It introduces the business rescue regime. It introduces a number of important principles protecting employees and enabling employees to be involved in the governance of companies, which is an important tradition.